Yes, please. Yes.
English Lordship.
Yes.
Lordship, I may be allowed to move an urgent unlisted motion.
What is that urgency?
Lordship, by order dated 3/10/2023, the Deputy Commissioner Timahor, who is also the chairman of the District Disaster Management Authority, directed the petitioner to demolish her own building, which was constructed over the Padal land within a period of 5 days. Lordship. I received the immune order only on 7th. Therefore, I could file the
When is the 5-day expiring?
yesterday, Lordship.
Yesterday it is
All
expired.
conviction was taken till date.
Okay. Okay.
Published.
May I please, Your Lordship?
Yes, please.
I beg to mention item number 27 on behalf of Sabungla Changmala.
Yes.
Hearing item number 27. Finally, list the matter after 2 weeks.
On the prayer of the learned government advocate, this is the case after 2 weeks.
Much on that.
Yes.
Next, Lordship.
Yes, please.
Lordship, I beg to mention item 34 on behalf of Mr. Gauhati
Yes.
for respondents.
Yes.
Lordship, can you let them come up to 1 week?
After?
A week, Lordship.
Lordship, in that case, let it be listed after the puja break.
Twenty-four.
On the prayer of the learned counsel for the parties, listed after 2 weeks. Okay.
Vice Mayor.
For admission, item number 30.
Yes, where is Mr. Yangarwati? Where is Mr. N. Muzui? We have listed this case to seek for some clarification, just one clarification. And the presence of Mr. Yangarwati is required. Is he around? Where's Mr. Yangarwati? Any idea? Mr. N. Muzui?
Lordship, my senior, he's in court number 2.
Okay. Okay, revised list, revised list. If, Madam, if you can kindly inform Mr. Yangarwati to be here. I just want to get one clarification. Just one clarification, small. Oh yes, Mr. N. Muzu is there. Yes. Mr. Muzui,
Lordship.
we have already finished the order, we have drafted everything, but there is one small clarification which I wanted from Mr. Yangarwati.
Lordship.
This Rule 16, CCS rules.
Lordship.
CCS rules, Rule 16 is a different provision. I am not finding this very word which he has used.
Lordship, in fact, there are different publications.
Let's
Of, Swami.
just in my table.
In some,
No. Listen. I think in my table there are CCS rules. In my table there are 3 books. In my table. Oh.
Lordship, in some publication, there are different publications, Lordship, and the contents are not different, Lordship, but there's a little bit of variation.
No, it's not a question of variation. It's a question of actually CCS 16. I find that actually like what he has quoted, the petitioner has quoted here.
Lordship.
It's not found in the book, CCS 16. I've gone through, I had actually gone through CCS, this pension rules, 1972. That is also different, CCS rules. This is also different. So I wanted, from where did he get this rule 16? This, as per the CCS rules, Rule 16, this is procedure for imposing minor penalties. And the one which he has quoted is family pension.
Yes, Your Worship. Apparently in the repetition also he has quoted the rule 16.
And CCS pension rules 72, it's different. So I don't know from where he has quoted this, I just wanted some clarity on this.
I'm informed he's out of station, Worship.
Because we have finished drafting the order, but I wanted to get some clarity on this, that's why this was listed today.
Yesterday,
He was referring to this, I think,
no, in fact, he was referring to 3 books, Worship, yesterday. 3 books.
when is he coming?
Tomorrow. This evening,
This evening.
This evening.
Okay, so he'll be there
Yes,
tomorrow.
Yes, sir.
And
But this,
CCS pension rules, Rule 16 speaks about counting of service as apparentance.
yes, Your Worship. There were
But
confusion with the books, Your Worship.
no confusion with the books, but actually the provision, there should be no confusion.
Yes, the provision, Your Worship, we should be relying on Rule 50.
Rule 50 of,
The CCS pension rule, Your Worship.
Rule 50
Rule
of,
50,
just wait, this is pension. Rule 50,
yes, sir.
CCS pension, rule 50 of what? CC.
Pension rule.
Pension rules.
Yes.
Okay, this is Rule 50.
Surplus floor.
Rule 50. Subclause,
6 year.
Rule 50.
Okay. Your Honor,
Yes.
in this matter to be taken up after some time.
After some, kindly go through all this and
Yes.
come, okay?
Yes.
Because there is only confusion on this issue. If not, we are ready with
I'll
you.
highlight it after some time.
Yes, okay.
Pleasure.
Yes, please.
For admission, item number 1.
Yes. Who's for the government?
Not this Lordship. Lordship, I have instruction to apply for the private respondent, 6025, Lordship.
Where's your affidavit, Government?
Lordship, can we run off sometime?
I think this is continuing over a period of time. Kindly expedite.
There is some confusion here, Lord.
What confusion? What is the confusion?
A worker employee has to be verified by the district level verification law.
These are all issues.
No, no.
It should not come up at this time.
No, Your Lordship, what happened is that the petitioner was not verified
So verify.
for 10.
You are.
2015. That is the reason why respondent number 2, the Department of Kohima has rejected.
You are making such a small issue into such a big issue. You yourself are creating all these issues. File affidavit first. You are for?
For respondent 6 to 25, Lordship.
Who is 6 to 25?
Private respondent, Lordship.
Then why have they been pleaded 6 to 25? Yes, ma'am, why have they been pleaded 6 to 25? What is your prayer in the case?
For regularization of my service.
So how is the 6 to 25 affected?
Illegal appointment. They were illegally appointed, Lordship.
Against the post to which you were entitled?
No, they were my juniors, which they were their service were regularized.
Okay, juniors were regulars, okay.
Lordship, I filed my Bangla number this morning.
Okay.
3 weeks time it is good.
Mr. Muajamir, the learned government advocate, senior government advocate, as well as Mr. Your good name,
Not yet one, Lordship.
so and so, are granted 3 weeks' time to file their respective affidavit in opposition, listed accordingly.
For admission, item number 2.
Please, Lordship.
Yes, please.
Lordship, in this matter, pleadings are completed.
Okay.
Let it come up for hearing.
You file your affidavit in.
Yes, sir.
Okay, pleadings complete. It is submitted by the learned counsel for the parties that pleadings are completed and the matter can be taken up for hearing. Listed for hearing in the usual course. Okay.
Once or please.
For admission, item number 3.
Please, Your Lordship.
Yes, please.
Lordship, I have received the counter filed by the state this morning, Lordship. So
Yes,
if
we
I may
did.
be allowed some time to go through it. And
What about respondent number 7?
they're yet to file, Lordship.
No.
Lordship, respondent number 7, we were directed to take Dusty.
Yes,
Status one.
yes,
So,
yes.
Lordship, we have filed our Dusty affidavit. to
Affidavit,
that
who is
respondent.
respondent number 7? And where is your affidavit? Affidavit is 15 September.
Lordship,
Affidavit is dated.
10/8/23.
It can't be 10/8 when the order is 14/9. 14/9/23.
Lordship,
You were,
we were
directed to take-
directed to take steps prior to that, Lordship. 21/7/23 was the order,
Okay.
was the direction to take Dusty. And then
Okay,
it was
okay.
listed again on the 14th.
So the deemed served.
Yes, Lordship,
Yes,
yes, Lordship.
Okay. Who is 7 anyhow?
7 is, Lordship, the Western Sumi Kukami Hoho, represented by its president, Lordship.
Okay. Yes. Miss Mary? Are you in this case?
Yes, Your Lordship.
Have you filed your affidavit?
Yes,
Lordship, I have received it this morning, Lordship.
Okay,
So
what
if I
about,
may-
what about,
Lordship, respondent number 8 is also yet to file, Lordship. Mr. Fusako,
Who is respondent number 8?
Mr. Pushito Kiban, Lordship, from Tiluku village.
Who is the counsel? Mr.
Mr. Fusako,
PB
Mr.
Paul.
PB Paul, Lordship. They are also yet to file their counter, Lordship.
Okay. MS Lucino, the learned counsel for the petitioner, submits that she may be allowed 2 weeks' time,
3 weeks
3 weeks' time to file affidavit in opposition.
in reply, Lordship.
Affidavit in reply to the affidavit in opposition filed by the state respondents. Are you for?
Lordship, I'm for risk number 8.
What is your
I'm
affidavit?
also yet to file. Lordship, I'm awaiting instructions. Any given time, Lordship.
Mr. Fuseko, the learned counsel for the respondent number 8,
Lordship.
also seeks for 3 weeks' time to file affidavit in opposition on behalf of the respondent number 8, on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Pledge, Lordship.
For admission, item number 4.
Yes, Your Lordship.
Yes.
I'm praying on behalf of Livika. Here she has sent the affidavit for vetting. So this may kindly be listed after 2
Okay.
weeks, Your Lordship.
The learned government, MS Inaholi, the learned government advocate, submits that the affidavit on behalf of the state respondents has been sent for waiting and therefore seeks for 2 weeks' time to file the affidavit in opposition. Prayer is allowed, listed accordingly. Okay.
Give your blessing.
For admission, item number 5.
May I please, Lordship?
Yes, please.
Lordship, in this matter, we are yet to file our affidavit in reply. Kindly grant us 2 weeks' time.
You are for the petitioner,
Yes, ma'am.
Mr. Manu Konyak, Mr. M. Konyak, the learned counsel for the petitioner, is granted 2 weeks' time to file affidavit in reply, listed accordingly.
Give your blessing.
For admission, item number 6.
May I please, my lord?
Yes.
My lord, in this matter, pleading has been completed, my lord, so let it come up for hearing.
Okay. It is submitted by the learned counsel for the parties that pleadings are completed and therefore the matter can be taken up for hearing. Listed for hearing in the usual course. Okay.
For admission, item number 7.
Yes.
Your Lordship, I'm making a prayer on behalf of Livika, Your Lordship. She's yet to file, so kindly grant 3 weeks time to file counter, Your Lordship.
Okay. And
My lord, let it be 2 weeks.
2
on
weeks.
this matter, yes.
Why? What is the difference between 3 weeks and 2 weeks? What benefit you are getting?
No, actually, the matter has been pending for long.
22 matter.
Yes,
I have seen.
and on the petitioner.
What is your case?
My guess is that the petitioner was serving as essay in the scale of pay. And as per the scheme of the government,
Correct.
he has to be recognized on.
He has served for how many years?
35 years.
35 years.
Yes, and now he has been retired since last month.
During the pendency of the petition?
No
Or
more.
you are coming to the court after retirement?
After retirement.
Okay. The learned government advocate is granted 3 weeks' time to file affidavit in opposition. Okay.
Pleasure.
For admission, item numbers 8 and 9.
Your Lordship, I'm making a prayer on behalf of Livika, Your Lordship. 3 weeks time to be granted to file, Your Lordship.
Okay. The learned government advocate is granted 3 weeks' time to file affidavit in opposition.
For For admission, item number 10.
Please, Your Lordship.
Yes.
Your Lordship, here pleadings are completed, so it may be listed for hearing.
Okay. It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be taken up for hearing. Listed for hearing in the usual course.
Yes, Your Lordship.
For admission, item number 11.
Yes.
Lordship, I feel it as a duty to point out to your Lordship, page 62
Of?
the writ petition. In the second paragraph,
62.
there are two orders, 3/8/2018 and 7/2/2019.
You are reading page 62.
62, second paragraph. The paragraph starts with, in view of the prevailing extraordinary situation. There, Lordship will find two orders, 3/8/2018 and 7/2/2019. These two cases are the cases Lordship may recall, are the orders passed in the account case. It is a matter for regularization in service. And then can we come to again page 63? Paragraph 10. The same orders are reflected. And then paragraph 10.
The Health and Family Welfare Department should inform the Honorable High Court in view of the judgment dated 3/8/2018 and
7/2/2019.
Plus in connection with regularization of government employees.
Yes. And then 65. Page 65, clause F.
The earlier decision?
Clause F.
The earlier decision of the cabinet to regularize? That one?
Yes.
The service of existing regular name of one stands revoked in view of the legal opinion given.
Legal opinion appears to be in connection with these two orders, in connection with the regularization and service Lordship, where
in view of the legal opinion given. So?
these are the cases when Lordship was the senior additional advocate general and then the rate appeal has been filed by the state.
Yes, Mr. Is there any difficulty for this court?
I feel it as a duty to point out.
Apparently. Okay, listed before any other bench without me. Okay.
There were other similar cases like this.
Item 14 also will be the same.
Okay.
There, the government has enclosed the two orders, which Lordship has argued also, and then they are relying on those two judgments.
Okay. Listed before other bench without me, and at the appropriate bench. Yes. Same with item?
Item number 14.
Item 14. Item 14. Same with item 14. Okay.
For admission, item number 12.
Yeah, please, Lordship.
Yes.
Here I am appearing for response number 6 and 7. I'm yet to receive the instruction, so kindly allow me to extend.
What about CGSC?
Lordship, here for 1 to 5, Mr. YP Gupta is appearing for the railways.
Okay. Yes, Mr. Tiba. What is your prayer?
Here, I'm yet to receive instruction, madam.
Your 4R
6 and 7.
6 and 7. Mr. E. Tibapom, the learned government advocate. 6 for 2 weeks' time to file affidavit in opposition on behalf of respondent number 6 and 7. Stop. Prayer is allowed. Listed after 2 weeks. Stop. None appears for the respondent number 1 to 5. Stop. The interim order passed earlier shall continue till the next returnable date. Okay.
Obliged, Lordship.
For admission, item number 13.
Please, Your Lordship.
Yes.
Your Lordship, I'm mentioning on behalf of the council for the respondent number 4. Private respondent number 4. Kindly allow me.
Are you the counsel for the respondent number 4?
No, my name is not reflected.
Okay. Who is the counsel?
Mr. Adam Mohammed sitting in the other.
Okay. 4. What is your prayer? Ma'am, what is your prayer?
Your Lordship, it may be listed after 2 weeks to file affidavit in opposition.
Okay. Okay, for. What about the government?
They have already filed their affidavit.
They have filed their affidavit.
Yes, Your Lordship.
Very unusually, huh? Okay. MSV There makes a mention on behalf of Mr. Sentiangar, the learned counsel for the respondent number 4. And 6 adjournment of the case for 2 weeks to file the affidavit in opposition. Stop. Prayer is allowed. Listed after 2 weeks. Okay.
Your Lordship.
For admission, item number 15.
Yes.
Your Lordship, here I'm yet to receive instructions. So
Okay.
kindly grant me 3 weeks time, Your Lordship.
You're for the petitioner, ma'am?
Yes, Your Lordship.
MS Inaholi, the learned government advocate, 6 for 3 weeks' time to file affidavit in opposition. Prayer is allowed. Listed accordingly.
Much obliged.
For admission, item number 16.
Yes.
Your Lordship, kindly grant me 3 weeks time to file my affidavit.
Okay. MS AIME, the learned government advocate, 6 for 3 weeks' time to file affidavit in opposition. Stop. Prayer is allowed. Listed accordingly.
Obliged.
For admission, item number 17.
Wait, please, Your Lordship.
Yes.
Your Lordship, kindly grant me a further time of 3 weeks, Your Lordship, to file my affidavit.
Yes, Mr. Taka.
My lord, there is an urgency for disposal of this case.
What is that urgency?
Lordship, the Lordship may kindly grant me a minute, 2 minutes time. Lordship, the issue relates to whether the retrospective state of regularization given to my similarly situated person as well as my juniors from the date of decision of the cabinet should also be extended to the petitioner or not. That is a simple legal issue involved.
Lordship is well aware that by government memorandum dated 18/2/2004, people who had completed 5 years and 10 years of service were given or were regularized in service to the scheme. The date of decision of the cabinet was 16/1/2004. So that was the date of decision on the basis of which, Lordship, the similarly situated persons who had completed 10 years of service, as well as the petitioner's junior, who had also completed 5 years of service, were given the retrospective regularization with effect from 16/1/2004, that is the date of decision by the cabinet. Whereas this is relating to teachers. Whereas, Lordship, in case of the petitioner, that benefit has not been given, though his case was recommended on the ground that he had completed 10 years of service as on 16/1/2004. My Lord, thereafter, Lordship, having realized that he has been unfairly dealt with, the principal director, by a letter dated 24/2023, has recommended my case that my seniority should be reviewed like the other similarly situated person. Lordship, the date of decision is 16/1/2004. So, Lordship, so the legal simple issue involved
The
here.
decision of the cabinet,
Yes, Lordship.
16/1/2004.
And that was the basis by which,
When were you regularized?
my Lord, I was regularized only on 18/5/2010. Because my case was also recommended in the year 2004, along with the other persons who had completed 10 years of service as on 16/1/2004. I was left out then.
Why were you dropped?
My Lord, that is the issue. My case was recommended, I had the requisite qualification, everything, but due to the negligence of the respondents, I was left out. Now, having realized the mistake, the principal director, after I represented in personal interview, my case was recommended that my case should be reviewed to the government by the appointing authority, the principal director, on 24/2023. That no decision has been taken. What has happened, Lordship, is that my juniors, who were regularized even after completion of 5 years of regular service, as on 16/1/2004, they are already promoted to the post of assistant headmaster. Now they are under active consideration for further promotion to the post of headmaster.
And you are still a graduate teacher?
I'm still a graduate teacher. But because, Lordship, 10 years, 5 years, as on 16/1/2004 were all regularized from the date of this decision, that is 16/1/2004.
After screening case, is it?
Lordship is well aware that for 10 years of service, no screening test is required.
Okay.
For 5 years, it is screening test.
5 years.
Yes. So after screening test, even my juniors, they are already assistant headmaster, now they are under verge of promotion to headmaster. So, my Lord, in that view of the matter, my Lord, my respectful submission notice was issued by this honorable court in the month of July. So the only legal issue to be decided here, Lordship, is that whether retrospective date of regularization should be given from the date of decision to the petitioner, like the other similarly situated person as well as his juniors, who has been given regularization with effect from 16/1/2004. That is the only legal issue involved. So my respectful submission, yes, time may be given.
Whether this 10 years, 5 years, regularization after 10 years, 5 years, whether actually this was also set aside by this court?
My Lord, if I remember correctly, 3 years issue was 3 years was set aside in the related issues which we have dealt. There, the issue involved was relating to 3 years of service. However, my Lord, the issue is relating to the past, whereby government has already regularized, and Lordship is well aware that in those account matters, when those issues were dealt with, Lordship is well aware that the single bench as well as the division bench did not disturb with the already settled issues who are regularized persons. The only direction was that henceforth, no more regularization, but the past regularization succession was not disturbed by this honorable court, by the single bench as well as the division bench. So my respectful submission, my Lord, in view of all the developments, my Lord, it requires little explanation disposal.
Ms. Mary, you make an endeavor to file your affidavit. We'll give you sufficient time.
Yes. And the next thing, my Lord, an endeavor will be made for disposal, because
Okay.
the only issue is one legal issue.
Yeah, for disposal, let us wait, but let us give them at least an opportunity to file the affidavit.
Lordship, fine, fine.
No.
On the reasonable date, my lord, my humble prayers that if endeavor be made.
Yes, MS S. Murray, the Leonard Senior Government Advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Stop. Mr. Takamasa, the Leonard Senior Government Advocate, the Leonard Senior Advocate, assisted by MS so-and-so, Learned Counsel for the petitioner, submits that there is some urgency for expeditious disposal of the case. Stop. In view of the submissions made by the Leonard Senior Counsel for the petitioner, the Leonard Government Advocate shall make an endeavor to file the affidavit in opposition on or before the next date fixed, listed after 4 weeks.
This will be on 13th of November, Lordship.
Listed on 13/11/2023.
Much obliged.
Yes.
For admission, item number 18.
Your Lordship, on behalf of
Yes.
Livika, she's yet to receive instructions, so kindly grant 3 weeks time to.
Okay. The Learned Government Advocate, 6 for 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed accordingly.
Much obliged. For admission, item number 19.
Your Lordship, similar prayer here also on behalf of Livika, kindly grant 3
Okay.
weeks time.
No objection, Your Worship.
Item number 19, same one.
For admission, item number 20.
May I please, Your Lordship?
Yes.
2 weeks time may be granted to file affidavit in reply.
Okay. MS so-and-so, the Learned Counsel for the petitioner, is granted 2 weeks' time to file affidavit in reply, listed accordingly.
Obliged, Lordship.
For orders, item number 21.
Your Lordship, I'm yet to receive the parawise comments, so kindly grant it.
Yes, Ms. 4/2/18. What is the case, ma'am?
Lordship, the present petitioner, he was excommunicated for lifetime from his own village.
Are they excommunicated?
Yes, Your Lordship.
Take back. Take back your excommunication order. You have no authority to excommunicate somebody. You are the village, you have no authority. Yes, government, you are the main person.
Your Lordship, I'm yet to receive the instructions, so kindly grant me 3 weeks time. Your Lordship, in the present case, the government has to make their stand clear if they will file an affidavit, Your Lordship, because the issue pertains to the infringement of my fundamental right, Your Lordship, Article 21, my personal liberty.
You should have in fact directed the village council to withdraw the order, if not to take necessary action as per the law. How can you excommunicate somebody from the village? Mr. No, there is no justification, there is no justification. Somebody's liberty has been adversely affected by your order and we'll give you one more last chance, government. We'll give you one more last chance. MSAIME. Are you mentioning on behalf of somebody? The Leonard Government Advocate, as well as Mr. Wati Jamir, the Leonard Counsel for the respondent number 4 to 18 is granted 3 weeks' time to file their affidavit in opposition. Stop. It is made clear that there shall be no further adjournment for filing the affidavit in opposition by the respondents, listed accordingly.
Your Lordship, on the next date, the name of the leading counsel, Mr. Sentianger, his name will be reflected in the court list.
Okay. The name of Mr. Sentianger, the learned counsel for the petitioner, shall be reflected in the daily court list. Okay. File your affidavit, file your affidavit.
For orders, item number 22.
Yes, Mr.
Yes, Your
Tumpo.
Lordship, by the last order, I was directed to file an affidavit on service of notice on the Lokayokta. I have filed the affidavit. The Lokayokta seems to be represented today, and the interim is to be taken up.
If the Lok Ayukta is present, let them file affidavit, we will see.
We have also received the affidavit from the state respondents, Your Lordship.
May I please, Your Lordship?
Yeah, yes.
There should be instructions to appear for respondent number 4, that is Nagan Lokayukta, Your Lordship. Your Lordship may kindly allow 2 weeks.
What, Mr. Tompo, what is the matter about?
Your Lordship, the petitioner is a treasury officer, senior treasury officer.
Oh.
Now, as per the rules, treasury rules, he cannot refuse any payment, he has to make it. And then, as and when excess troubles are detected, he will make the officer who has thrown the money to recover it. That is the rules.
So have you told the officer to recover?
They have recovered it.
They have recovered.
And normally it is the authority which give him the direction to recover it, he does it. No recovery was made. Now here in this case, an Upper Lokayukta took over the matter and then made recommendations for taking away my
DPO power.
without any suspension. Now I cannot function because the deputy commissioner has been given the power to take charge of my office. Then in the meantime, again, subsequently,
Who has given that power to the deputy commissioner?
the directorate, that is the finance department,
On the basis of the recommendation.
on the basis of the recommendation of the Upper Lokayukta. Then what happened subsequently again, another order came out from the Upper Lokayukta, which is also impugned hearing. Now, as per the order also, since no crime was detected, now a recommendation was made for censure against me. Now, a memorandum, the impugned memorandum was issued as to why.
Who has made that recommendation for censure?
The Upper Lokayukta. And this is the position. Now the law is very clear. The law says I cannot refuse when bills come. Yes, proper checking should be there, but once it is done, if errors are there, I may correct. But intimation should be given to the trouble authority, the officer who has submitted the bills. Now the law is also very clear that I cannot refuse any bills. I have to pay. Only when excess troubles are detected, it is my duty to get it recovered.
So you have recovered.
So I have recovered accordingly. And now it has been made into overblown the issue by the Upper Lokayukta, and now I am at a receiving end. So the investigation, the inquiry and the reports are against the rules, Your Lordship.
Were there any disciplinary proceedings initiated?
Office memorandum, the impugned office memorandum was issued, giving me the opportunity to submit my reply.
So you have submitted.
I have submitted.
Now, what
I
is
have
the-
also taken the same stand.
What is the outcome?
It is in process. That is why no inquiry has been conducted by the department, but office memorandum was issued. I have submitted my reply. It is still pending, and now it is more than 5-6 months since the OM was issued. So after I submitted my replies, since no action was being taken, I have been compelled to approach this honorable. So I have prayed for interim to state a
No, during
the orders in the-
during the proceedings of the disciplinary process,
Yes.
whether it will be proper for this court to issue the interim order.
In the instant case, since I have acted only in accordance with the rules, and the authority also knows it.
Objection to that.
The authorities also know the fact that.
What is your objection in law?
Lordship, the first thing is, Lordship, the order of the Lokayukta is in the nature of recommendation. So no rights of the petitioner has been violated.
But on the basis of your recommendation, some action has been taken.
But Lordship, the order of the Lokayukta does not operate on its own. Further action is called for by the competent authority, Lordship. And Lordship, if you see the main prayer, and prayer.
Yes, government.
Inquiry is going on, it's still pending, so granting of interim at this stage will be in the
Okay,
interest of justice.
okay. We'll give them time to file their affidavit.
Lordship, may I make
We'll
a
consider.
suggestion, Lordship?
Have you filed your affidavit?
No, Lordship.
Then file your affidavit.
Your Lordship, since this is an urgent matter.
No, there's no urgency. There's no
Yes,
urgency. There's no
my
urgency.
prayer, my humble prayer, Your
There's no
Lordship,
urgency.
because against the rules, I am being punished. Your Lordship,
Your power has been exercised by some other officers.
presently, yes.
So public interest is also not affected.
But my right has been affected, Your Lordship. I am acting only in accordance with the.
Okay, the departmental inquiry has been initiated, so it is for the departmental inquiry to find out what is actually the truth of the matter. So let us see, let us give them a chance also, let us not rush things. Since actually the power of the DDO is now exercised by the Deputy Commissioner of the district.
Your Lordship may kindly consider the rules. I'll take Your Lordship.
No, let them first file their affidavit, let us see after that, let us see. Because at this juncture, maybe I am not inclined.
In that case, Your Lordship, since the state respondents have already filed the affidavit.
Status filed.
State respondents has already filed the affidavit.
Your Lordship, we have initiated the inquiry based on the recommendation of the Lokayukta.
Yes.
So Lokayukta has to come with the reason.
The matter may be taken up on the basis of the affidavit.
It's up to the authority whether they will accept our recommendation or to reject our recommendation.
If it is against the rules, you reject.
Yes.
Madam, if it is against the rules, you reject. You instruct your government if it is against, if the recommendation is against the rules.
Yes.
You reject. If the recommendation is as per the rules, you proceed. That is the only issue.
So the matter will be taken up, Your Lordship, on the basis of the affidavit filed by the state respondent.
No, we'll give a
They
local.
are challenging our order, we need to file our.
Yes.
4 weeks time, we are granted to file.
Mr. Mr. So-and-so, the learned counsel for the respondent number 4 has entered appearance and is granted 4 weeks' time to file their affidavit in opposition. Listed accordingly.
Apply.
Yes.
From the supplementary course list, revised item number 30.
Yes.
Yes, sir. No, this Rule 50 is about debt gratuity. However, Rule 54, Your Honor.
Rule 54 of?
CCS pension rule. Rule 54, this family pension 1964, Your Honor.
Rule 54. I'm not getting it. Oh, this. Yes, what do you want to?
Clause 6, Your Honor. Clause 6 speaks about the period for which family pension is payable. And clause 8, Your Honor.
Just wait.
Yes.
54?
Clause 6
Clause-
talks about the payment.
Just wait. Clause 6.
Clause 6, the period for which family pension is payable. Subclause 1, Your Honor. In case of a widow or widower up to the date of death or remarriage, whichever is earlier.
Just wait. Clause 6.
Yes, Your Honor. Clause 6, subclause 1.
Disabled family pension payable to children widows shall be stopped. Parents shall be deemed to be.
And clause 8, Your Honor.
I'm not getting your clause 6.
Oh.
You are jumping here and there, but. Okay, give them this book. This is, give them both this pension compilation. Give them both this. Let us see. CCS rules. Oh, so this is confusing.
Have stated, in different books, the numbers are different.
That is what I'm finding.
Because I have given one of my book, the Gauhati also. They also the.
You don't have a text which is uniform.
No, we don't have lordship. Because the author is the same, Swami.
Swami.
There's one author, Sarkar.
Swami.
Swami and Sarkar.
But I think Swami is quite renowned.
Yes,
for this.
Swami, yes. But even in the Muthu Swami, there are 3-4 editions where the rules are different. That's the confusion also.
So we have to pass any order very cautiously.
Very true.
So far as pension matters are concerned,
In fact, I requested the officer, the Accountant General, to give us the rule, the exact.
which one? 6? This one?
Yes.
The period for which family pension shall be as follows. Subject to first, in case of widower, subject to first provision. Subject to first provision. In case of widower, up to the date of. This is rule 54 clause 6. So what is 1? What is clause 1? That is subject to clause 1. If a person who in the event of is eligible to is charged with offense, murder, and so, or a beating commission, and so, his claim to receive his shall remain suspended till the conclusion of the criminal proceeding. Okay. So, okay.
And Your Honor, clause 8.
Clause 8.
Yes, sir.
Clause 6. This is clause 6.1, correct?
6.1, yes.
6.1.
Yes.
6.1, then 6, clause 8.
8. 8.2. I'll be relying on 8.2, Your Honor.
Clause 8. 6. 5. 6. 6. 6. 8.2. If a deceased government servant or pensioner leaves behind a widow or widower,
Yes, sir.
the family pension shall become payable to the widow or widower.
Yes, sir. Here, the right of the widow or the widower has more priority than the children.
If the family benefit shall not be payable to more than one member of the, if the deceased family member is behind a widow, the family benefit will become payable to the widow, paying which to the eligible child. Okay, now what happens to your petition?
Yes, you're right.
That is the issue. What happens to your petition? Now your petition is completely different from what you are now actually citing.
Yes,
so what happens to the petition?
We will be allowed to withdraw and file a fresh order since our prayer is relying on Rule 16, Your Honor. And that's the difficulty. And the submission which I'm making now, I'm relying on Rule 54.
Tare, you have wasted my whole night.
For amendment, then, Your Honor.
Amendment these days, CIS, I don't know, something is very wrong with the instructions also. But the amendment in the main petition, this will remain. So I think withdraw and then in your application, new petition, you also stress on the office memorandum which has been placed by the government.
Yes.
In terms of that.
Yes,
Okay, so that we can issue a short direction on the basis of that.
Yes, sir.
Without going through all those round and round.
Yes, sir.
Now, I don't know.
Apologies, Your Honor. But due to the confusion in the books, Your Honor.
Yes, we have already drafted the order and kept. Just to clarify this.
Apologies, Your Honor.
You actually file a fresh petition emphasizing on this rule which you have cited. Kindly, I think you take the initiative.
Yes.
Your younger what is too casual. Without reading the entire provision, if he finds a line which is actually applicable to him, immediately bring out that and then paste it in the petition. That should be avoided. And this is exactly what actually the petition says. Just going through the books, finding some provision which is actually favorable, just extract that, paste it. And during the hearing, actually, it is found that that is not relevant in fact, that provision. So you just emphasize your petition on 2 points, on what you have submitted today and then on the 2015 OM, just on that.
Okay.
And then just make a prayer to direct to actually seek for a prayer to actually go by the process of 2015 and then I think we can dispose of the petition on that line.
Yes, sir.
On the prayer of Mr. Zat Kulnu. You are also petitioner, na?
Yes.
Counsel for petitioner, Mr. Zat Kulnu. The learned counsel for the petitioner. Oh, no. Mr. Zat Kulnu. Please cancel everything. Mr. Zat Kulnu, the learned counsel for the petitioner, submits that he has instructions to withdraw the present writ petition with liberty to file afresh. Stop. The writ petition is allowed to be withdrawn with liberty to file afresh.
Yes.
Okay.
Much obliged, sir.
There's so many. Yes, Mr. Kulnu, I think this is your book.
Yes, sir. Yes,
So kindly hand it over.
For motion, unlisted motion, item number 31.
Take me to your impugn order.
Page 22, Lordship. Page 23 is the type copy.
Please read it.
Lordship. This is order dated 3rd October 2023. The District Disaster Management Authority, Dimapur, for mitigation of disaster has taken cognizance of the situation where heavy downpour of rain has resulted in flooding, waterlogging, and spread of dengue disease in various localities under Dimapur town. And whereas on spot verification conducted by a team and official from Dimapur Land and Record Survey Office, DMC, Urban Development Department, and District Administration, it is found that apart from blockage of public drainage due to garbage and siltation, various illegal encroachment in the form of construction of building over the land reserved for the public drainage have been detected. This illegal construction have resulted in obstructing free flow of water, thereby causing flooding, waterlogging, and breeding grounds for dengue, mosquito, and other waterborne diseases. And whereas to prevent any impending disaster or further spread of dengue cases, it is expedient to order demolition and removal of the structure and buildings that is come up over the public drainage. Now, therefore, in the interest of public service, Section 34 Key and Section 34M of the Disaster Management Act 2005 is hereby invoked, and the below mentioned individual is directed to demolish and remove that portion of the building and structure that has encroached, this is more than encroached, Lordship, encroached and or come up over public drainage within a period of 5 days from the date of passing this order. Failure to comply with the directives contained herein shall entail action as per relevant laws, including forceful demolition.
What is your right over this land?
Lordship.
What is your right over this land? Where is your pata?
Yes, in the year, Lordship, page 15.
Yes.
16 is the type copy. It was allotted in the year 1983. And Lordship, page 19.
Where is your allotment order?
It is Lordship on the right hand side. Approved by order number so dated 29/1/1985, and ADC order REV 17 so dated 4/3/1985. And page 19, Lordship, is the revenue receipt.
What is your pata number, dog number? Pata number is 607.
607, Lordship.
What is dog number?
Dog number, Lordship,
808.
Block 4, Moza 2, Dimapur.
Block 4. Block 4.
H18. Moza 2, Dimapur. Page 19 is the revenue receipt. 20 also revenue receipt.
What is your page 18? What is this? Jama Bandi status. What is it?
Yes, Lordship.
What do you mean by Jama Bandi status? Jama Bandi status. This is the revenue payment receipt.
Yes, Lordship.
Page 17.
Yes. That was issued on 27/9/2023.
What is this Jama Bandi status? What is this?
That was issued by the authority, Lordship, by additional, Lordship,
607. Zama Bandi status. Approved white government order number so and so, and it approved white. Okay, let us see. Approved white government
page 18, Lordship, that copy.
Zama Bandi status. Approved white government order number.
And I'm paying my land revenue tail tips. Annexure 19, page 19 and 20, Lordship.
Zama Bandi status. Who has issued this Zama Bandi status?
Down below, the authority seal and signature is there.
This is
Surveyor, Lordship, surveyor.
record keeper or page 17. You are referring to page 17.
Yes, Lordship.
Who is that authority?
Down below, Lordship, surveyor, Lordship.
Surveyor.
Record branch.
Approved white government order number 2. What is your Zama Bandi? What does white government order number?
Lordship, it is
Approved white order number 23083. Okay. And ADC's order revenue is 1780. You don't have a legible copy of this?
no, Lordship. But I've lost my original and I've applied for the duplicate copy, Lordship.
So where is the duplicate?
This is the duplicate copy, Lordship.
No, the legible copy of the, because duplicate should be very
This is the
clear.
only documents furnished by my client, Lordship.
Then page 19.
Page 19 is the revenue receipt, Lordship. Button number is there, Lordship. Doc number is also there. Page 20 also, Lordship, revenue receipts. I paid my revenue till last month, Lordship. Lordship,
What about page 21? What is this?
page 21 is the succession certificate. Lordship, quota was issued in the name of my late husband, who expired in the year 2016. And this is the succession certificate.
Succession is for pension.
Lordship, I've made a specific statement that I've applied for modition also, which is pending before the authority.
But this is not relevant. Then what is that?
And the next page of the Indian Water, Lordship.
Yes, Mr. Kiangami. It seems that actually this is a allotment issued by the government.
Yes, there is a pata shown here, but a schedule is not indicated, Lordship, whether the encroachment, the pata covers the encroachment area or not. And these involve public interest. Now, the dengue situation, everybody knows, water logging, everybody knows. And
We'll give you just 7 days time.
Lordship,
You get some instructions and come. Just see, because actually now you have the petition.
Lordship,
You have the petition, copy of the petition.
Lordship.
So you just see whether actually the petitioner has encroached beyond the land allotted to him. You are right, because in Dimapur, such instances are prevailing. 100 feet will be allotted, the person occupies 150 feet. So I think, let us consider the interim on the next date.
Lordship,
Of course, till that date, we'll give you protection, but we'll just give 7 days to the government.
just one clarification, Lordship. The allegation is encroachment.
No, allegation is engrossment.
Lordship, if there is any allegation of encroachment, the proper procedure has to give notice under the Nakalin eviction from under.
No, all these days when actually public interest is involved, not necessary, because actually you are seeing the situation in Dimapur.
Lordship.
You are seeing how actually the floods are causing so much sufferings and distress to the
But
people.
Lordship, what aspect of the matter? The building was constructed in 1980s, Lordship.
Let us see whether whether you are within your allotted land or whether you have actually gone beyond that. We will see. At least let us first ascertain that. Within 7 days, you actually come with the proper instructions. Okay. Heard Mr. Wati Jamir, the learned counsel for the petitioner, and Mr. N. Angami, and Mr. K. Angami, the learned senior government advocate for the state respondents. Stop. This petition has been moved unlisted today. And an interim prayer has been sought to suspend the order dated 3/10/2023 passed by the Deputy Commissioner cum Chairman, District Disaster Management Authority, Dimapur, Nagaland. Stop. On perusal of the impugned order, this court is of the view that for hearing on the prayer for the interim, the learned senior government advocate should apprise this court with necessary instructions. Stop. Accordingly, this petition is again listed for motion on just 7 days on? Yes. On 17/10/2023. Stop. Till then, the order dated 3/10/2023 passed by the Deputy Commissioner, cum Chairman, District Disaster Management Authority, Dimapur, Nagaland, shall remain suspended.
Worship, one thing, if not yet added upon, I hope it's not yet added, authority is not yet.
Okay, if the said order has not been acted upon.
Lordship, I've stated paragraph 7, no action has been.
Let us see, who knows, they must have acted. Let us.
Okay.
For hearing, item number 23.
Yes,
Lordship.
Mr. Fuseko.
Lordship, this Honorable Court on 18/9/2023 directed the petitioner to place the
18.
gift deed,
Yes.
certified true copy of the gift deed issued by the revenue as well as the register. Lordships, I'm aware that the office of the TC, Dimapur, is undergoing shifting. But due to that, they are unable to furnish me the documents, Lordship. So, if Lordship may kind be gracious enough to grant some time.
When do you think it'll be over, the shifting? I know, I'm aware about this.
Yes, Lordship. That I cannot disclaim, but at least some more time, Lordship. Lordship, that we have been pursuing on our letter dated 5/9/2023, and on that strand, the surveyor has given us some documents, but that doesn't suffice. Only the status of the Jama Bandi, except for the status of Jama Bandi and the Jama Bandi, which shows that.
Okay, we give them some time because actually the deputy commissioner's office is under shifting, and all the files are actually like in that transition stage.
Lordship, and it's not a small office; it's a big
I know
office.
that.
So Lordship would take some time. Okay,
You-
Lordship, at least we're pursuing, Lordship. We're pursuing.
Okay.
Lordship, make
Yes,
gracious
Mr.
enough to list.
Fuseko, the learned counsel for the petitioner submits that all efforts have been made by the petitioner to comply with the order dated 18/9/2023 passed by this court. But in view of the shifting of the files from the present office, from the present deputy commissioner's office, Dimapur, to the new location or
New
to
location,
the new building
Lordship.
at Purana Bazaar, to the new building
Purna Bazaar.
at
Purna Bazaar.
Purana Bazaar,
Purna Bazaar.
Dimapur. Some more time will be required to comply with the order dated 18/9/2023. So, in that view of the matter, in view of the submissions made by the learned counsel for the petitioner, 4 weeks' time is granted to the learned counsel to the petitioner to comply with the order dated 18/9/2023. By which the petitioner has been directed to file affidavit enclosing the certified true copy of the gift deed dated 1997, okay, which is registered on 8/12/2015, and also the certified true copy of the relevant pages of the register in which the registration of the said gift deed is recorded.
Lordship.
Listed after 4 weeks.
Lordship. In the meantime, interim may be continued, Lordship.
Okay. The interim order passed earlier shall continue till the next returnable date. Make an effort. Make an
Lordship,
effort.
definitely, Lordship. I would like, Lordship.
For hearing, item number 25.
What is this? Yes, Mr. Vito, Mr.
Here, the petitioner husband died in harness.
Well, Mr. Mazui, this is also relating to pension. Why, what is the issue here?
died while in service. He worked for 16 years, 1 month, and 13 days.
16 years?
Yes,
Yeah,
and
yeah.
then died in harvest. So the wife is here before the court, seeking a direction from the court to grant her pension benefit, family pension.
Why actually the government has not granted her the pension? Why the government? What is the reason?
Here the question of interpretation of the rule will come later. But first the matter has to be clear to the government that the law issues.
Why, Mr. Beto? Why, if actually the petitioner is the wife of this is government servant, why actually she should not be entitled?
Lordship, I have already stated in my paragraph 5, 6,
Uh,
7, and 8.
What is your use?
In paragraph 7, I have stated that as per the CCS pension group, Lordship, the petitioner is not eligible, Lordship.
Why? That's why.
Lordship, here as far as the CCS pension goes, more particularly CCS.
Are you, Mr. Beto?
Lordship.
Are you? Firstly, please answer me this. Are you denying that the petitioner is not the wife of the deceased government employee?
No, Lordship, that we are not denying.
Okay.
To that extent, Lordship. However, Lordship, during his lifetime, Lordship, the petitioner husband was never regularized, Lordship. He was on work charge, Lordship. So, if you go by the CCS pension rule, Lordship, the rule 2, which clearly states that those who are not eligible, Lordship, for pension are the person in casual and daily related employment. And secondly, person paid from contingency, Lordship. So the CCS pension rule is very clear, Lordship.
Again, this is the problem, Mr. And Muzui. What is the rule? Have you filed your affidavit?
No,
All these things should be forthcoming from you. All these things should be forthcoming from you. Because you are the only expert. The petitioner may be she is under the impression that she has a right. The government says no, the petitioner has no right. So ultimately, to guide the court, I think it is you who should come up with the rules. Yes.
The petitioner's husband died in harvest.
Correct.
While serving as work charge. So the 15 OM will apply.
15 OM. No, suppose if after following that process, if suppose the Office of the Accountant General says, no, work charge employees are not entitled, then actually it will be futile, for the petitioner, for a poor petitioner to run around to comply with that 15 OM. And then finally saying, the authority saying that no, you are a work charge employee, you are not entitled. So why don't we first come up with a very clear instruction? And then under which rule? Your affidavit actually should always be supported by the rules. Because this is something to do with pension. You have not filed your this thing. This court, I think you will appreciate that this court time and again in pension matters has been requesting you to come up with a proper affidavit supported by the rules, either for or against, whether entitled or not. So we'll give you time kindly. Okay. Yes. Madam, we are going to give 4 weeks time to the Accountant General to see whether you are eligible for pension or not. Okay. Let us first clarify. Mr. Ann Muzui, the Learned Standing Counsel for the respondent number 10. Is granted 4 weeks time to file comprehensive affidavit as to whether the petitioner, who is stated as to whether the husband of the petitioner, late husband of the petitioner, who is stated, who is stated to have expired while serving as a work charge employee, is entitled to the family pension under the rules. Please come with clear instructions, because you are the only source who can actually like help this court to dispose the case. Okay, listed after 4 weeks. Okay, ma'am.
For hearing, item number 26.
What is this case?
Please, Your Lordship, I am mentioning on behalf of the counsel for the petitioner, Your Lordship.
Okay.
Can you list this matter after 2 weeks?
You are the counsel.
No, I'm not here in this case, Your Lordship.
Because 14/9/2023 shows that MSV NE There, Leonard Counsel for the petitioner.
Yes, Your Lordship, my name may be reflected, but I'm not in the, I've not been engaged, Your Lordship. I was mentioning on behalf of the counsel for the petitioner.
And today also same.
Yes, Your Lordship.
What is the matter about? This is Imti Longchar. Imti Longchar, it will be a pension matter, if I'm not mistaken.
Lordship, here in this case, the petitioners, the service of the petitioner was terminated, so he's challenging that, Your Lordship.
Oh. Okay. But Mr. Santi Younger is also here.
Yes, Your Lordship.
You are mentioning on behalf of whom?
Mr. Santi Younger, yes.
Imti Longchar or Santi Younger?
Both of them, Your Lordship.
Both of them.
Yes.
You can take up. You are efficient. I know. Next time, come prepared.
Yes, Your Lordship, that,
Okay.
it may be listed after 2 weeks.
Yes, I know. You are quite efficient to take up cases. So you come prepared on the next date. Argue, okay?
Yes, Your Lordship.
Okay.
My lord, here I'm appearing for respondent number 1.
No, who are the other respondents?
Number 2 is it? Respondent number 2 is represented by Asangla Wale.
Oh. Oh, Nagaland Rural Bank. He was an employee of the bank.
Yes, my lord. It is the case of misappropriation of fund. Here the main respondent is respondent number 2.
Correct. What is this Asangla Walling? Huh? I think she has finished up the fees, so no more interested. MS V There. Next time, come prepared, okay?
Yes, Your Lordship.
MS V There makes a mention on behalf of Mr. Santi Younger, the learned counsel for the petitioner, and seeks adjournment of the case for 2 weeks.
Yes, Your Lordship.
For 2 weeks. Prayer is allowed. Listed after 2 weeks. Mr. E. Tibapong, the learned government advocate, appears on behalf of the respondent number 1. None appears on behalf of the respondent number 2.
Much obliged.
Yes.
For hearing, item number 28.
Please, Your Lordship.
Yes, what is this again?
The the petitioner, he was appointed as Ward Charge Khalasi, Your Lordship.
Well, list the case after the disposal of WA 27/2022. This WA 27 is disposed.
Yes, Your Lordship.
Well, have you enclosed a copy of the order?
No, Your Lordship.
You kindly furnish. Because, okay, let us see, because here, list the case after the disposal of WA 27/22. You give one copy to madam. You give one copy to her. So that actually, because actually, I think some order has been passed to list this case after disposal of WA 27/2022. You read and come. You read and come.
Your Lordship, I'm aware of this case, Your Lordship.
Are you aware?
Yes, Your Lordship.
Para by para.
Your Lordship, it is my humble submission that this case will not cover my case because.
My lord, the instant case is covered by the judgment passed in the WA 27 of 2022.
Your Lordship, because it is my humble submission that in this case, Your Lordship, the writ petitioner he has not completed 30 years, Your Lordship, even though he was on scale pay. And in my case, Your Lordship,
This is that the judgment passed by Justice Suman Shyam and Justice Devashish Barua.
Yes.
It is covered. Your case is covered by this. Your case is covered by this. I will take you to one particular paragraph. Let us see. That's why I was telling you to go through and come.
yes, Your Lordship.
Let's see. Yes, you read this, Mr. Thibapom, this page 14 of 17. Page 14 of 17. Okay? Okay? You got it?
Yes, Lord.
Yes. See the third line, starting from the third line, the matter could have, okay? Page 14. Page 14, okay? Up, you see up 14/17. Up. 14/17, you are on that page, na?
Yes.
Okay, you come to the third line. 1, 2, 3.
Yes.
The matter. You got it?
Yes.
On the right, the matter could have been considered from a different angle had the respondent met the requirements of the scheme and had approached the court seeking regularization prior to his retirement. At this stage, consideration of the prayer made by the respondent may call for creation of a supernumerary post for regularization of his service, which would not be permissible in the facts of this case. In the case of Union of India, so and so, Supreme Court has held that the High Court, in exercise of its power under 226 of the Constitution of India, cannot direct the state government to sanction and create posts for regularization of a part-time employee. Very clear.
Your Lordship, I believe in this case, Your Lordship, certain facts has not been brought to the notice of
The
this
law,
court.
let us, small facts may make some difference, but what about the law?
Because Your Lordship,
This court has clearly stated that if actually you had come before this court after fulfilling the scheme, the conditions under the scheme, if you have come before this court, it would have been a different matter. But you are coming after retirement.
yes, Your Lordship.
So in that case, to accommodate you, this court may have to direct the government to create a supernumerary post. And that has been deprecated by the Supreme Court.
Your Lordship, it is my humble submission
So
that.
go through and come.
Your Lordship, kindly allow me to satisfy this honorable court, and I will leave it to the wisdom of Your Lordship, whether to dismiss.
What more to satisfy when the Honorable Division Bench has clearly laid down? What more to satisfy?
Because, Your Lordship, when we look at the scheme does not talk about sanction posts, Your Lordship. Even under the 2015 scheme, it talks about regularization by conversion of chairperson into regular ones person to them, Your Lordship.
That is why you could have actually taken that recourse when you were in service.
Your Lordship,
after you have retired, how can this court direct the government to regularize your service? When during the lifetime of your service you had not been regularized by the government. After your retirement, how can this court direct the government to regularize you? That would be against Uma Devi's case.
Your Lordship, what has happened is that the petitioner is hardly educated. He can hardly write his name. So why Your Lordship? He has made a verbal request to the department. However, it was not considered. And moreover, he was released prematurely, Your Lordship. But in the present case, he is not challenging that, Your Lordship. He is only claiming for regularization as per the scheme, as per the 2004 scheme, Your Lordship.
2004 scheme is worse again for you because of that Honorable Supreme Court's order. That Honorable Supreme Court's order, Heshini. Nishivi. That is actually like where 2004 scheme was involved. That is worse again.
Your Lordship, but the facts of that case and in the present case is different, Your Lordship.
No. This court does not find any difference.
Because under that case, the husband of the writ petitioners was not entitled under the scheme. And that was, in that case, pertains to posthumous regularization. Here, the petitioner is seeking for retrospective regularization, Your Lordship.
What is the difference between posthumous and regular retrospective? What is the difference? Posthumous means after the date.
Yes, Your Lordship.
Retrospective means actually like you want a regularization from a date before.
Yes, Your Lordship.
More or less same. Only the name posthumous, retrospective, that may actually like be some difference, but.
Then, Your Lordship, kindly allow me to give a brief submission on these three office memorandums. And, Your Lordship, I will base my submission on these three office memorandums, Your Lordship. Kindly allow me.
Okay.
Your Lordship.
But I have gone through your case.
Yes, Your Lordship.
Relief may be a different thing.
Yes, Your Lordship. I leave it to the wisdom of Your Lordship for that.
Okay.
Your Lordship, kindly allow me to rely on the Nagaland Work Charge and Casual Employees Regulation Act as only one, Your Lordship.
Yes.
If I may allow.
Yes, which section?
If Your Lordship may kindly come to section 2D. Section 2D, Your
Work
Lordship.
charge?
Yes, work charge employee means an employee engaged without sanction post under the work charge establishment.
And where is the scheme provided for regularization? By which provision?
Section 12. Section 12. Scheme for absorption of service. The state government may draw up a scheme for absorption of service of work charge employees into regular government service.
So that scheme has been drawn.
So, Your Lordship, a harmonious reading of these two sections, Your Lordship, it can be ascertained that the Act it does not envision regularization of the service of work charge employees on a sanction post, Your Lordship.
That is, this court is well conversant.
And, Your Lordship,
now come, you have read this 2001 Act, come to the scheme.
Yes, Your Lordship. So, a harmonious reading of all the two of his memorandums, Your Lordship.
Which scheme you are relying?
Lordship, I will.
When did you retire? When did you retire?
2014.
2014. When did the scheme? 2015 scheme.
Yes.
Okay, so Nishivi's case is applicable.
Yes, Your Lordship.
Nishivi's case. Where is that judgment order? Nishivi's judgment. You retired in 2014.
Yes, Your Lordship.
Correct. Okay.
Yes, Your Lordship.
What is that Nishivi's judgment? That order?
I have a copy of it, but I do not have the extra copy.
Mr. Thipa, whether you have Nishivis?
I don't know, but in the judgment which I have furnished, there the paragraph has been not included.
Para 11?
Para 16. Oh, para 11.
Para 11?
Yes.
Para 11. Yes, let us see the judgment. Please make photocopy. Make photocopy. Tell me,
Yes, Your Lordship.
if you can satisfy this court
Yes, Your Lord.
that this judgment of the Honorable Supreme Court
Yes, Your
supports your case, I'll give you relief.
Nishivi's case.
Yes.
Your Lordship, in my humble submission, this case will not cover my case, Your Lordship.
Why not?
That is
This is
because,
to do with 2004
yes, Your Lordship.
and 2004 schemes about the senior most being regularized.
Yes, Your Lordship.
You may not be the senior most.
Yes, Your
You may not be the senior most. So how can you say that? And actually, how can you say that this Nishevi's case will not cover your case? This has squarely dealt with the 2004 scheme.
Your Lordship.
And in this case, it speaks about the senior most. You may be a senior. You may have completed 30 years, you may have completed 35 years.
Yes, Your Lordship.
But if there are other work charge employees who have completed 30 years, 35 years and are still not regularized, where is the question of regularizing you? That is the issue here.
Yes, Your Lordship. However, when we look at the RTI, Your Lordship, those employees who are much junior to me has also been regularized.
Madam, I have told you on this aspect. I have told you if you want to bring in those persons, why not implead them? I have told you before.
Yes, Your Lordship.
Without impleading them, don't speak about them. You have no right to speak about somebody whom you have not impleaded. So don't speak about discrimination. You can actually raise the issue of discrimination only if you implead those persons whom you have not impleaded.
Yes, Your Lordship.
So don't bring in those persons because your petition is silent on those persons.
Yes, Your Lordship.
You have not impleaded them.
Yes, Your Lordship.
So just confine yourself to your case only.
Yes, that's why, Your Lordship, today I'm basing my submission on the three office memorandums, Your Lordship. Because all the three office memorandums...
You cannot base your case on a 2015 office memorandum.
Yes, Your Lordship. However, what I'm trying to say is that in all the three office memorandums, the scheme is silent as to whether the new scheme has supersedes the old scheme, Your Lordship. So...
You want to know that?
Your Lordship.
You want to know that whether actually the new scheme supersedes? Read this judgment.
Yes, Your Lordship.
Read this judgment.
But because in the scheme it does not talk about that, Your Lordship, regarding the...
The judgment says, the implication of this judgment.
Yes.
Have you read this judgment?
Yes, Your Lordship, I have.
Then, if you have gone through this judgment, then you should not be making such a submission. I will take you to this. Yes, come to page 9. Come to page 9 of 17. Come to page 9 of 17. Para 8. Para 8.
Yes, Your Lordship.
Read, come to the 1, 2, 3, fourth line, the last, starting with the word the. Okay?
Yes, Your
The.
Lordship.
Okay?
Yes.
The scheme of regularization introduced in the year 2004 contemplates a process of regularization to be carried out against 50% earmarked vacancies based on the criteria of seniority come merit, whereas under the scheme of regularization introduced by OM 17/3/2015, only those who have completed 30 years or more of continuous service as on 1/1/2015 would be entitled to be regularized. Now the relevant portions. Read here. Although there is no indication in the notification as to whether the scheme introduced in the year 2015 supersedes the earlier scheme of regularization, yet by necessary implication, it can be presumed that the scheme 2015 has replaced the previous scheme in holding this field. See?
Yes, Your Lordship.
What more? So 2004.
Yes, Your Lordship. Then I leave it to the wisdom of the Honorable Court, Your Lordship.
So let us say 2015, you were appointed when 2015 scheme was not there, and you were retired in the year 2014.
Yes.
That is before the coming into force of 2015 scheme.
Yes.
So let us assume that your case is covered by 2004.
Yes, Your Lordship.
And if your case is covered by 2004, should we sideline this the Nishevis case?
Lordship.
Everything is chained. You cannot break that chain and say that this is different, this is different. Everything is chained.
Your Lordship.
It's like a spider web, see, everything.
Your Lordship, respectfully, I believe the Nishivi's case is judgment in personam and not judgment in ring, Your Lordship.
No.
Because in that
It
case,
is-
she was not represented.
It is to do with 2004 scheme. What more? What more? The Honorable Supreme Court has clearly decided this 2000, the rights of the petitioner on the basis of the 2004 scheme. What more?
Yes, Your Lordship, I leave it to your wisdom.
Okay, we pronounce the judgment.
Yes, Your Lordship.
Okay.
Yes, Your Lordship. However, my citations may be, Your Lordship, I would like to place 2 citations, Your Lordship.
Yes.
May be reflected in the order, Your Lordship.
Yes. Any citation?
I'm relying on that judgment was passed in WBC, W827 and 29 of 2022.
Which one?
W827 and 29 of 2022. I've already submitted before your lordship.
This
Alampa case.
Oh, just wait. W827.
Yes, my lord.
Yes, you are relying on which case?
AR 1961 SSC 647.
Yes. Have you got the citation?
Yes, I have placed the citation.
Yes, let's. Have you got the citation with you?
Yes, Your Lordship.
Oh, this one. EIR
1961 SSC
1961 SSC
SC, not SSC, Your Lordship,
SC?
I'm humble apology. 647.
647
Yes, I'm relying on paragraph 7.
para 7 and this is
On the 7th line, Your Lordship.
para 7.
Yes,
And then the next one, let us see, let us read. Para 7.
Para 7th, the 7th line. The 7th line.
The answer to this question?
Yes, Your Lordship.
No, this does not support your case. Okay. Next. What is your next?
AIR 1981 SC. 852.
AIR 1981
SC.
SC.
852.
852. Para?
Para 13. This one is also more or less same with the previous one, Your Lordship.
Para 13.
Yes, Your Lordship, paragraph 13. It talks about if the provision is capable of 3 constructions, then the one that benefits the workman, the employees has to be.
Where is the scope? What is the scope for this court to interpret the provision?
Yes, Your Lordship.
Which will be more beneficial to you? Where is the scope for this court under the 2004?
Your Lordship, because.
Where is the scope for this court to interpret the 2004?
Your Lordship, at the cost of repetition, Your Lordship, since all the three office memorandums, leaving aside the judgment that was passed recently.
Don't talk leaving aside the judgment. You should not actually make such a submission because actually the judgment is all in relation to the office memorandum.
Because, Your Lordship, in my humble understanding, Your Lordship, respectfully, I believe that case does not cover my case, Your Lordship. So.
I'm sorry, ma'am.
Yes.
Because actually, what are the 3 notifications? Let me see. The 3 notifications which you are submitting?
The 2001, 2004, and 2015, Your Lordship.
Oh, 2001 is not notification. 2001 is the act. 2001 is the act. 2001 is the act.
Your Lordship, there is an office memorandum, Your Lordship. Even in 2001, office memorandum was issued with regard to regularization of work employees, Your Lordship. On seniority come merit, Your Lordship.
Okay.
So,
2001.
Yes, Your Lordship.
But what is that 2001 relevant to this case?
Even in that office memorandum, it talks about seniority on the basis of.
Whether the government has actually stated that 2001 memorandum is still applicable, enforced?
No, my lord.
You file an affidavit then.
My lord, that one, I need to say that. But my lord, here, in regard to the facts.
No, let us see your petition. Where have you stated that you are relying on 2001 notification? Let us see your petition.
No, Your Lordship, in my petition, I have only relied on 2004 and 2015.
Then no, nothing more, nothing less.
So, my lord, even though the petitioner case is covered by 2004, but the petitioner is not eligible. Because it talks about seniority come merit. So for the seniority, the petitioner.
Where have you stated in your affidavit?
Affidavit in the opposition, para 5.
Let us see your paragraph. One, 2, and 3. Respondent number 1, 2, and 3. Para 5. Yes, please read.
That in regard to the statement made in paragraph 6, 7, 8, and 9, 10, and 12 of the writ petition, the answering deponent respectfully submits that in compliance with the Honorable Court dated 22/7/2021, the respondent authority had considered the petitioner case. However, on perusal of his report, it was discovered that the petitioner case does not come within the purview of the office memorandum dated 17/3/2025, the 17/3/2015, as he was released from service on 31st/3/2014.
Correct.
On attaining the age of subordination, and the decision taken had been conveyed to the petitioner by letter dated 06/10/2021. It is also pertinent to mention herein that even though the petitioner case is covered by office memorandum dated 22/9/2004, the respondent could not consider the case because, as per the said office memorandum, it clearly states in paragraph 4 that work charge employees will have the right to consider first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior-most work charge employees in the relevant category will be regularized subject to his or her fitness for the vacant post. As such, as per the seniority list March 2013, he is in
Seniority list,
seniority
March-
number 602. Therefore, by superseding his seniors and violating the standing office memorandum, the respondent authority could not consider the petitioner's case.
Okay, good. So you have annexed the seniority
Yes,
list,
my
and in
lord.
the seniority list, he is in
Yes.
602.
Yes, unacceptable.
Yes, ma'am, your case gets worse and worse.
Your Lordship,
Have you anywhere in your petition stated that you are the senior most among the senior work charge employees?
no, Your Lordship.
So that is actually what 2004 scheme speaks about.
Yes, Your Lordship.
The senior most amongst the senior work charge employees.
Your Lordship, that is their contention, but Your Lordship,
That is not the contention, that is actually the scheme.
no,
And that's why I'm asking you whether in your petition, because Nisheve's case
yes, Your Lordship.
is exactly that. That's why I'm asking you whether in your petition you have actually stated that you are the senior most among the senior work charge employees to be eligible to be regularized under 2004 scheme.
No, I have not stated that,
You
Your
have not
Lordship.
Okay.
However, I may be allowed to reply to this, to the paragraph that was read.
Have you filed your reply?
Yes, I
Have you
filed my
filed,
reply.
what is your reply to that seniority list? Just
Your
give me
Lordship, may
that.
kindly come to my.
What have you
affidavit
stated?
Reply paragraph 5.
Ah.
That the statements made in paragraph 5 of the R1 to 3 IO is not admitted for the same is unreasonable, misconceived, and arbitrary, and the petitioner reiterates the statements made in paragraph 10 to the writ petition.
Okay.
The contention of R1 to 3 is believed by RTI reply dated March 2021, written by the additional chief engineer and PIO PhD, made on 10/2/2021. As per the RTI reply, as many as 195 were charged employees were regularized by the department from time to time. Among those 195 employees, 39 of them were regularized without completing 30 years of service, whereas 29 of them were below 10 years of service and 8 employees
Madam.
were regularized.
On this issue,
Yes, Your Lordship.
I have repeatedly told you,
Yes, Your Lordship.
you want to claim the similar benefits,
Yes, Your Lordship.
whether you have impleted them.
Yes, Your Lordship.
I have repeatedly told you to implead them.
Yes, Your Lordship, I understood.
Knowingly, you have not impleted. So that's why I'm telling you now,
Yes, Your Lordship.
I'm actually requesting, no, don't bring in those persons now. Don't
Yes,
bring
Your
in
Lordship.
to claim similar benefits
Yes, Your Lordship.
because you have actually not impleted them.
Yes, Your Lordship.
So without impleting somebody, we can never take up the case of that person.
Yes, Your
And
Lordship.
have you challenged the seniority list which is enclosed by the government?
No, Your Lordship. With regard to this seniority list, Your Lordship, it has come to my knowledge only after they have filed their application.
That's why after it has come to your knowledge,
Yes,
you could have certainly challenged this seniority list.
Yes, Your
You
Lordship.
have not. What
Yes, Your
more?
Lord.
Beyond the scope of the seniority list, how do we expand ourselves?
Yes, Your Lordship. But the department, they are not following this office memorandum, Your Lordship.
No, they have.
Even though they have raised this contention in their affidavit and position, Your Lordship.
That is your submission, which
Yes, Your
this court may or may not accept.
Yes, Your Lordship.
And this court is likely not to accept that.
Yes, Your Lordship. I leave it to your wisdom.
MS. We tell the learned counsel for the petitioner and Mr. E. Tibapo, the learned government advocate for the state respondents. Stop. Heard the parties at length. Judgment and order reserved. Okay?
Deeply obliged, Your Lordship.
For hearing item number 29.
Yes, ma'am, what is this?
Your Lordship, here I'm praying for a minimum scale of pay.
Minimum scale of pay.
Your Lordship.
Affidavit in reply to the affidavit in opposition has been filed. Mr. Tiba, you are the counsel?
Uh,
Who's?
Moy Intin.
Where is your comparison with similarly situated employees? In which paragraph have you stated?
Your Lordship, I stated in my affidavit in reply at paragraph 4, page 2.
Affidavit in reply.
Paragraph 4.
Yes. Yes, Mr. Moa. Have you forgotten your case? Have you forgotten your case?
My Lord, I was having a conference. I networked it. I beg apologies.
Like you don't forget your lunch and dinner, you should not forget your case. Yes, what do we do with this case? Equal pay for equal work.
Greetings has been completed, Your Lordship.
And this is also listed for hearing.
Yes.
Is it listed for hearing?
Yes, Your
This
Lordship.
is item number
29, my lord.
29. So what do we do?
Now, if the petitioner is agreed, then I'm okay, Your Lordship.
Why if she is discharging the same work, why don't you pay the minimum scale of pay at least?
Your Lordship, absence of any policy framed by the state.
That is not a ground for you to deny.
But then, suppose if we grant, then all the ethics employees will sick.
Very good.
That's the problem.
Very good. Who has appointed them?
We have appointed them, but Your Lordship, they are appointed without the sanction post.
It's all right. Sanction post and equal pay for equal work, these are all totally different. Yes, totally different. If you are appointing, and then if you are telling one person to do the work of a peon, which the peon of a regular cadre does, you have to pay him at least the minimum scale of pay.
Moreover, Your Lordship, some cases, similar cases are waiting for the.
That's all right. That's all right. Let it be pending. No issue, because all the cases are on different facts. Just because the principle of equal pay for equal work is involved, and that is in appeal in a particular case, it doesn't mean that actually just because appeal has been filed in one case, that the fact that the appeal has been filed will not actually stop the other cases. We'll proceed. You.
We'll fix the date.
But please don't, government advocates don't give that submission, that the similar case appeal is pending. We are not going to accept that. You appeal,
Yes,
and then if your appeal does not succeed, what happens? Do you think that all these cases should be kept in a pending stage perpetually?
Yes, Your Lordship was saying that before. So
Yes.
I agree.
So we are not actually, if You have difficulties, then you can take a time to hear the matter after 1 or 2 weeks. But that should not be a ground. The pendency of the appeal in other cases should not be a ground. So we list it for hearing. We list it again after 1 week, 2 weeks.
After 2 weeks, Your Lordship.
Okay. On the prayer of Mr. Moemchen, the learned senior government advocate, list the case for hearing.
Admission hearing, Your Lordship. Admission.
No, after 2 weeks. That's why I'm saying you are not even actually like in that knowledge where you are. This case is listed for hearing.
Yes, Your Lordship.
So why should it come up again for admission? You want to demote the case?
Lordship.
After 2 weeks, okay? Okay, after 2 weeks, come prepared. Yes.
Yes, sir.
Tadi nak cerita